Just a brief history for those that don't know. Also, an additional caveat, if you're an expert in oil and gas, this may be a bit elementary, so bear with us. The idea is to give every participant the basic knowledge and the basic understanding of this area of law. In 1956, oil was first discovered in commercial quantities in Oloibiri, which is in the present-day Bayelsa State. It was discovered by a company called Shell Dachi, which, as we know now, is Shell. They've been here since 1956 doing business. In the late 60s and 70s, more players in the Nigerian petroleum industry emerged. Majority of the Seven Sisters came into Nigeria and were all exploring for oil. Nigeria joined the Organization of Petroleum Exporting Countries in 1971, which is OPEC. And just where are we currently? And as you may all know, getting data in Nigeria is pretty difficult. So apologies if this is the 2020, 2019 data. 2020 data says we have 37 billion barrels of proven crude oil reserves, which makes Nigeria the 13th largest oil producer in the world and the largest in Africa. However, our current crude oil production as of January was 1.4 million barrels a day. I know before COVID and the disruptions COVID came with, Nigeria was producing about 2.5 million barrels, but we're down to 1.4 million barrels now. And people usually say Nigeria is an oil country and Nigeria is an oil country. But many experts have said Nigeria is an oil country surrounded with gas. We have more gas than we have oil. We have over 200 trillion cubic feet proven gas reserves, which is the 10th largest in the world and the largest in Africa. And this goes without saying, about 65% of federal government revenue is derived from oil. 88% of our forex is gotten from oil. So we see the position Nigeria occupies in the global oil market. And sometimes it's ironic that we are where we are, with being the largest oil reserves in Africa and also the largest gas reserves in Africa. And as we woke up today, we're hearing things about fuel queues and increase in prices, and watching what's going on. But we look to the value chain, and this picture essentially tries to capture the entire value chain for gas and for oil. Sometimes they're merged, sometimes they are on a standalone basis. And we can see here where the oil field is, where with the drilling occurs, and the oil is explored in this area, and then you drill, you find oil. When it comes out, take it to the terminal. You can also see the FPSO, which is a floating production, storage, and offload vessel, which is also utilized in drilling in the deep offshore areas. As we go along, I will explain most of these terms. And you can see the image is well partitioned into three: upstream, midstream, and downstream. And this is particularly important as you go along in understanding the different regulators and the different tax implications of what part of the divide that you fall. So for the upstream, which are the essential oil and gas players, they drill, get the oil, and it gets to the terminal. It moves through a pipeline to the midstream region, and then straight to a refinery. Here, the refinery takes on the crude oil and separates it into different byproducts. And those refined products are transported and utilized in our homes, or in our cars, and in our different offices. There's also another alternative where the crude oil goes to the refinery, and rather than refined products, you get natural gas liquids. This is a scenario where the crude oil and gas are found together, essentially associated gas, where in the process of drilling for crude, you also see some portion of gas. In this instance, the refiner will separate the crude from the gas, and the gas goes as a natural gas liquid, and it goes to a fractionator, which essentially just distills the product, and it moves to petrochemical plants where the NGLs are utilized. Or it can move down to a gas processing facility where it's further distillated and the different byproducts of gas are found, and then it goes to a storage facility. That's for the crude channel. The gas channel also, there are gas fields here, and the gas fields where they are rich, liquid rich, which is essentially with water, gas mixed with water, it goes into a gas processing unit or facility. That unit will separate the water from the gas and essentially giving you dry gas. Dry gas goes straight into the storage facility, and from the storage facility, it goes to be utilized in the power plant, in the petrochemical plant, and in our relevant homes. Where it's not wet gas, you find dry gas, you don't need to process. So it goes straight to a storage facility and utilized in our homes. Also, you need to, because as lawyers, you always have to follow the money. So that in order to understand the liquidity of the market, you need to understand who's the off-taker. So if you see here, the power plants typically off-take the gas. Majority of Nigerians' power plants are thermal, and they utilize gas in the generation of electricity, which we all use in our homes. So when you pay for your electricity, the electricity company, and there are different channels, but I won't go into that because that's a different topic, they pay for the gas, and it's that amount of money that the gas companies utilize in developing gas infrastructure, gas facilities, and also to spend additional monies in further exploring for additional gas fields. So the impact that you and I not meeting our electricity bills in our homes is that there will be dearth in the infrastructure because the market won't be liquid enough in order to be able to enable gas players invest additional sums in the infrastructure that gets the gas from the gas field to our homes. I think that general understanding is very important because you understand why Nigeria has gotten to where we are as of today, why majority of us don't have constant power supply. It's because a lot of the facilities that get the gas have not been developed, and there's no incentive for gas players to develop gas because the power sector is not liquid enough to meet its obligations to the gas producers and the gas transporters. We move straight to the meat of today's presentation. And that's the legal and the regulatory framework for exploitation of gas in Nigeria. As we all know, the Constitution of the Federal Republic of Nigeria is the ground norm. It's the bedrock on which everything in Nigeria is built, including the legal and regulatory framework for the Nigerian petroleum industry. And this is a very important document because this gives you the fundamentals why and on how the entire petroleum industry is structured. Section 44.3 of the Constitution essentially vests the entire property and control in minerals and mineral oils and natural gas under or on any land in Nigeria and its territorial waters and exclusive economic zones in the federal government to be managed and prepared to be managed in the manner prescribed by the National Assembly. And you then move over to Section 4.2 of the Constitution, which essentially confers powers to make law, confers on the National Assembly the powers to make laws for all matters that are listed in exclusive legislative list. So essentially, once a matter is in the exclusive legislative list, the National Assembly, to the exclusion of all other legislative units, has the powers to make laws on such matters. If we take a very careful look at the part 1 of the second schedule, you will notice that item 39 specifically states that matters relating to oil and gas are amongst the issues listed in the exclusive legislative list. So essentially, only the National Assembly has the powers to make laws on matters relating to oil and gas. This is a very important point because we've seen where different states tried to also legislate on matters relating to oil and gas, and essentially make doing business for such oil and gas companies a bit difficult and cumbersome in their states. But it's clear that in the Constitution, only the National Assembly has the powers to make laws on oil and gas matters. Another important provision of the Constitution is Section 25, Section 20 and 51, which is the powers which grants the Federal High Court the exclusive jurisdiction in civil and criminal matters relating to mines and minerals, including oil fields, oil mining, geological surveys, and natural gas. You're wondering, why am I bringing this issue? This provision is very important because, as we all know, the principle of stare decisis. Our courts also make laws by their judicial pronouncements. And this has played out in the sector in at least 2 cases, which I'll discuss further because they're very important cases in the legal and regulatory framework of the oil and gas sector in Nigeria. As we said, the National Assembly is the entity that has the powers to pass laws governing oil and gas in Nigeria. The Petroleum Act was passed in 1969, and it vests the ownership and control of all petroleum in the federal government. This essentially just reiterates what the Constitution provides for. In addition to that, the Petroleum Act as well creates an office of the Minister of Petroleum Resources. The minister essentially exercises the general supervisory rule over all operations undertaken in the petroleum industry. As of today, the minister is our president, President Muhammadu Buhari, with a minister of state. Generally, the minister has the powers to make regulations in furtherance of the Petroleum Act. So in essence, where there are certain issues that need to be addressed, so long as the minister's regulations are in line with the terms of the Petroleum Act, then such regulations will be deemed to be valid. Other provisions of the Petroleum Act that are important. Here, the Petroleum Act restricts persons from constructing or operating refineries in Nigeria without obtaining a license from the minister. The Petroleum Act as well restricts persons from importing, storing, selling, or distributing petroleum products in Nigeria without obtaining a license from the minister. The Petroleum Act also creates certain offenses and stipulates the penalties for such offenses. So once you don't comply with the terms of the Petroleum Act, they'll be deemed to be an offense, and then the relevant penalties will apply. For example, if you undertake any of these steps without obtaining the minister's approval or a license, then you'll be deemed to be in breach of the Petroleum Act. The Petroleum Act also enables the minister delegate his or her powers to anybody in writing, save for his power to make orders and regulations. So generally, the minister may delegate his powers to another entity to take steps on behalf of the minister, so long as they're in tandem with the provisions of the Petroleum Act. And we've seen that play out we tend to see an entity called Department of Petroleum Resources, the DPR, undertake certain steps and take certain actions on behalf of the minister. Yeah. I mean, so if you want to undertake petroleum operations in Nigeria, what do you do? If you are qualified, you can apply for such authorizations to be obtained from the minister. There are generally three types of licenses or leases that qualified persons are entitled to apply for in order to undertake petroleum operations in Nigeria. And one is the oil exploration license, another is the oil prospecting license, and the major um, one is the oil mining lease. These are the three essential means of exploiting oil resources in Nigeria. And you will notice that in this uh, in this slide, there's nothing called gas license or gas lease. This is essentially premised on the fact that the Nigerian Petroleum Act, at the time it was passed, it was only premised or focused largely on oil because that's what they were searching for then. So it was largely oil. There was not enough focus on gas. Gas was somewhat as a byproduct, and that has also affected the way and manner in which gas has been seen and exploited in the country. And one important point to note is that only a company incorporated in Nigeria under the provisions of CAMA can apply for an oil exploration license, an oil prospecting license, or an oil mining lease. So in essence, a foreign company cannot be granted any of these licenses directly. They would first need to incorporate a company in Nigeria in order to obtain same. And then we start with the oil exploration license. Oil exploration license, this used to be used many years ago at the time where there wasn't sufficient information as to the data and the seismic data covering the different areas in Nigeria. So the minister would grant you a non-exclusive license over a very large portion of land to go in there, do studies, and find out if there's any crude oil contained within that large expanse of land. This is typically granted for 1 year because it expires on December 31st of the year that you obtain it. And it's usually renewable for only one additional year. But this has largely been phased out because there's now sufficient data as to where crude is located. Also, the government has moved away from giving very wide, uh, very rights over very wide expanse of land. So we've essentially moved away from issuing oil exploration licenses. Now we move on to an oil prospecting license. The oil prospecting license confers exclusive rights over the area of the license to enable you explore and prospect for petroleum. In that regard, you have it's different from the OEL, which was non-exclusive. Now it's exclusive. However, the area in which you are granted the OPL is smaller than the area in which the OEL was granted for. The duration of an OPL, as you can see, is longer than that of an OEL. The OPL is typically for 5 years. It should not exceed a term of 5 years, including any period of renewals. So essentially, no matter how many years you are given, you can't exceed a 5-year cumulative term. And we've seen ingenious ways by which this has been, I don't want to use the word circumvented, but has been structured in order to enable people that have not successfully recouped the investments in that 5-year period get additional time to do so. The rights that the OPL grants you is that the licensee is permitted to carry away and dispose of any petroleum that's won during this period of prospecting. So essentially, if you prospect and you see sufficient amount of crude, you can essentially sell that crude. Where you have found sufficient amount of crude, the expectation is that you should now, the expectation is that you should now seek a more definitive approval or license, which is called the oil mining lease. And the oil mining lease, yes, the oil mining lease is typically granted to a holder of an OPL who has satisfied all conditions imposed under the license. And in your prospecting, you have discovered oil in commercial quantities. What does that mean? Discovering oil in commercial quantities means that wherever you have found crude, it's sufficient to produce, the crude in there is sufficient to produce a minimum of 10,000 barrels of oil a day from the licensed area. So once you've successfully attained this, you can obtain an oil mining lease. The oil mining lease grants the leaseholder exclusive rights within that leased area. The area is typically smaller than the area granted under the OPL, but here you have additional rights. You can conduct exploration, prospecting, you can win, you can get and work, store, carry away, transport, export, or otherwise treat petroleum discoveries under the lease area. So essentially, you are entitled to whatever you get once you have the oil mining lease. You can deal with the products in whatever manner that you deem fit, so long as you comply with the terms of Nigerian law. The OML is typically granted for 20 years, but you're also entitled to a renewal. And there's a very important point to note here is that once you've complied with all the terms of the OML and you have made the requisite application in line with the provisions of the Act, which says that before the expiration of 12 months, before the expiration of your term of your lease, you should make an application for a renewal. And you have met all your obligations. So you've paid all your rent, your royalties, your taxes. The law says that the renewal shall be granted. This suggests that it's mandatory, that once you have met all the conditions, the minister is mandated to give you a renewal. In practice, we have seen many renewals granted over many oil mining leases. We've also seen where government essentially had certain renegotiations of terms, but still granted it. So we haven't seen where you have complied with all the provisions of the Act, the tax, your rents, your royalties, and you haven't breached, and the minister has failed to grant you a renewal. So this gives oil and gas investors some form of confidence because, as you know, oil and gas investments are pretty expensive. People spend billions of dollars, and they need to be certain that they can recoup their investments before the tenure of their term under the OML expires. Also, this is also very important when you're financing acquisitions of OMLs, because if a bank is going to give you monies to buy an oil block, the bank needs to be certain that you have sufficient amount of term under that OML in order for you to recoup your investments that will enable them get paid. So it's very essential to always note the term of an oil mining lease and to ensure that whoever is the operator or the holder of the lease meets and satisfies all the conditions in the OML, and in addition to making all the payments of its rents, royalties, and taxes. A very important point to note in the Petroleum Act, which deals with the ability of the holder of an oil prospecting license or an oil mining lease to assign its oil prospecting license or oil mining lease. Essentially, paragraph 14 of the first schedule of the Petroleum Act requires the minister to consent to any assignment of the OPL or OML, or any assignment of any rights, power, or interest in the OPL. This provision has been very, very controversial for a very long time, because very ingenious lawyers, if I may say so, have structured transactions in order to not breach this provision, and also to be able to undertake oil and gas acquisition transactions without obtaining the minister's consent. And we'll see this further down in the slides, where we'll talk about certain guidelines that have been issued by DPR. But I think I should spend some time on this provision. So what it is that as lawyers, we know that the first rule of interpretation is the literal rule. So if the literal rule says, and the literal rule is saying you take the words in their ordinary meaning. So if this provision of the Act, paragraph 14 of the first schedule to the Petroleum Act says, a holder of a license or a lease cannot assign its license or its lease or any rights, powers, or interest in the license or lease, how can an ingenious lawyer structure a transaction in order as not to breach this provision? So what people did was to essentially have, rather than have an asset sale, which was party A selling its OML, right? Which, I mean, as we've rightly read, requires the minister's consent. Transactions were structured on a share sale basis. So essentially, rather than sell the OML itself, ingenious lawyers would advise that you sell the company that holds the OML or the OPL. Because if you look at the literal interpretation of that provision, then you have not run foul of the law, because by selling a company, you have not sold the all mining lease, you have not sold any rights or powers or interest in the all mining lease. All you've just done is sold a company that holds an all mining lease. But you and I will agree that Nigerian regulators can be a bit difficult when it comes to taking away powers that they believe that the law has granted them. So this provision led to a very notorious case, the Monipulo case, where, as I previously said, a party sold the majority interest in a company that holds an oil mining lease. And I mean, from a literal interpretation, it looked fine. However, the Federal High Court in that case held that where you sell a company that holds, where you sell controlling or majority interest in a company that holds an oil mining lease, it will be deemed, you'll be deemed to have transferred or assigned that oil mining lease. So that now brought a lot of complexity, because I mean, that now meant that people could no longer freely do share transactions without getting the consent of the minister. Then, and I'm humbled to say that I worked on a transaction where we looked at the provisions of this act. We reviewed the case, the Federal High Court case in Monipulo, which unfortunately has not gone to the Court of Appeal or Supreme Court, because I believe the party settled out of court. But we reviewed both this provision of the law and the case, and there was an interesting structure that was utilized in assigning assigning in inverted commas interest in the OPL or OML. And what it was rather than, because as we said, Monipulo says if you transfer majority interest, right? What we did in that deal was that we didn't transfer majority interest. So we sold 50%, or the sellers sold 50% of a subsidiary that holds an oil mining lease. One, it did not breach the express provisions of Petroleum Act. Two, it did not breach the judicial pronouncement in Monopolo's case, because here 50% is not majority. You need 50 plus one share to be majority, as defined under our Companies and Allied Matters Act. So here, no majority sale was done. No transfer in the OML was done, but our regulators reacted. And further down the line, I'll show you where the regulators reacted. We now go to marginal fields. I mean, we all hear, I mean, this year there have been different talks about marginal field bid round. If you follow the news, you hear recently that DPR has issued letters to the prospective winners of the marginal field bid round. And so what are marginal fields? Essentially, marginal fields are fields that the president may from time to time identify as a marginal field. Typically, if you're an holder of an OML, because the OML covers a very large expanse of area, right? What government has done and what the Petroleum Act provides is that after the expiration of 10 years from the grant of the OML, you are required to relinquish half of the lease area. Because the understanding is that you can't be, I mean, you don't have the capacity to keep going all around checking. You look for where the crude is and you focus and you get your returns. So the other parts that may not be commercial for you, because it's really expensive, right? So as we said, let's rule of thumb, people spend $100,000 a day on drilling rigs, right? So if you're going to put a rig for 30 days, to drill a particular place, you must understand that whatever reserves you're finding in that area, whatever crude you're going to be getting, has to be large enough to be able to repay your costs, So depending on the players, sorry about that, it's a power break, but depending on the players, certain parts of the OML may not be competitive, cost competitive, because they don't want to incur so much cost for just 10,000 barrels of oil. So if you have those areas within your OML, upon the expiration of 10 years, you're required to just relinquish those areas. Those areas fall a pool of fields that the government will now farm out to other participants. This essentially was to drive indigenous participation in the oil and gas industry, because of the huge funds and the huge outlay of cash that was required to work these assets, many Nigerian entities could not participate. So the government thought about this very nice way of getting locals, Nigerian international companies to participate in acquiring some of these smaller fields that may not require as much capital, and also that may not be as attractive to the larger players. So what the press here, what you do is once those fields are relinquished, they form a bucket where from time to time government does a bid round and then issues those fields to indigenous players. What the requirements of the marginal field holders is that you're meant to enter into an agreement, because the field is typically lying within the OML of another, of the farmer, which is the person that first had the OML, right? The person that relinquished one half, So there is a provision where you have to enter into an arrangement with the farmer to pay certain compensation, and then you get a portion of that field, and then you start to work that field. Once you work it and you show verifiable evidence that you're working and you're commencing production, you are typically granted an extension of the 5-year marginal field timeline for the entire life of the reservoir. So essentially, the marginal field awards typically grant you a 5-year period. Once that 5 year is done, you must ensure that you have commenced production, or you must have shown sufficient progress to enable you get a renewal or an extension for the life of the field. And then, we have talked about how important the Petroleum Act is, and many of us would think that it's such a lengthy document. It isn't. It's a very short document, which you can read in probably about 1 hour. However, there are different regulations that have been issued there are different regulations that have been issued premised on the Petroleum Act. So there's the Petroleum Drilling and Production Regulation, which is the PDPR. This essentially provides the format for applying for OALs, OPLs, and OMLs. If you are a prospective acquirer of any of this, the application forms, the format for providing application forms are there. The supporting documentation that you will require or that will accompany your application as stated in the PDPR. And there are also some very interesting provisions in the PDPR. This is a very interesting provision which shows that whilst oil and gas matters are in the exclusive list, as it relates to land, OPLs, OPLs, and OELs, OPLs, and OMLs may be required to be registered at lands registries where there's a law in a state that requires such registration. So if you've ever seen a copy of an oil mining lease, if you look at the last page, you always see that it's typically registered in the land registry where the oil mining lease is situated. So this is the premise upon which that registration is done. Similarly, it enables the governor of such state retain any powers that are confided in the state as it relates to land relating to oil mills. And this also is a very important point because the next point, which is that holders of OALs, OPLs, and oil mills are required to comply with town planning laws. In a federal state like Nigeria, in a federal country like Nigeria, where there's always that constant battle of revenue generation between the federal and the states, you would know that many states have used this provision to ingeniously levy certain or require certain compliance levels from oil and gas companies as they try to mirror it with town planning laws. So it's always a very interesting discussion when you're having with the representatives of the states. But and these matters typically end by negotiation or in dispute resolution. Next is that the PDPR is also the base upon which the DPR essentially grants most of its consents. The PDPR is really the meat of any of the regulations that have been issued pursuant to the Petroleum Act. It shows that the DPR, it's under this that the DPR is granted the powers to issue certain permits to service providers in the oil and gas industry. It's under these powers that the DPR is required to approve the your drilling programs or in your fields. It's also the DPR is also required to approve your field development programs and any abandonment that you may be undertaking in your field. So essentially, the PDPR grants DPR several encompassing powers to monitor the operations of license holders in the Nigerian petroleum industry. This is another interesting point, which has to do with payment of rent. I mean, if, as you know, all mining lease, right? If you're a landlord, you must get your rent. Federal government is the landlord, so federal government must get its rent. Previously, you used to the government used to charge $10 for each square mile of an OPL and $20 for each square kilometer of a producing oil mill for the first 10 years, and then $15 for each square kilometer of a producing OML until the expiration of the oil mill and its renewal. You know that government is trying to raise revenue. There have been liquidity issues in Nigeria. So I think last year, the PDPR was amended and the sums that were payable as rent were increased. So I think all they just did was just add a zero next to the figures. So from 10, it went up to $100. From $20, it went up to $200. And from $15, it went up to $150 per square kilometer. And if you know how wide many of these oil mills are, then you understand the volume of the amount of money that government's getting as as its rent. But rent is even small compared to the next one. The PDPR as well provides for certain royalties that must be paid to the government. And royalties and rents are first line charges, i.e., those are the sums of money that go first before you do any other thing. Um, for onshore areas, the royalty rate is 20%, which is really huge, which is 20, the cost, it's significant. And however, for deep offshore and frontier basin and inland basins, the royalty rates range between 7.5 and 18.5%. And the reason for this disparity is that the government is trying to reduce the royalty rates for deep offshore, right? Essentially encouraging people to go further down because it's really expensive to drill deep offshore. So as an incentive for the big players, the government reduced the royalty rates for players in the deep offshore. There's also, the PDPR also provides for a royalty by price. And this has always been there. But I think many people have, the government looked over this. So essentially, there's a requirement to pay an additional royalty where the price of crude goes above $20. I think as of today, or it's about $70. So essentially, right now, all producers should be paying an additional royalty by price because the price of crude has exceeded $20. And that's for crude. But for gas, the royalty for gas is 7% for onshore areas, and the royalty for gas is 5% for offshore areas. And you're wondering why is the royalty for gas this low when the royalty for oil is that high? This goes back to the premise where I stated that generally the Nigerian petroleum industry was structured to exploit oil, and gas was just a byproduct. So government, by having these lower rates for royalties for gas, is trying to encourage more players to invest in gas infrastructure, gas saving infrastructure, rather than just flaring the gas, which we'll discuss subsequently. And then we go over to another regulation that was issued pursuant to the Petroleum Act. This is the petroleum regulations. This essentially governs the importation and the storage of the importation and transportation of crude. So this regulation essentially provide for the conditions that you meet or an importer will meet in order to import petrol into Nigeria. The type of vessel you are using to import the petrol, what are the other products that the vessel can contain, and the manner in which the vessel is going to transport the petrol to Nigeria. So these petroleum regulations have very detailed provisions, essentially covering the importation of petroleum and also the transportation from one port to another port within Nigeria. And it also provides for the petroleum regulations as well, also regulate issuance of licenses for storage of petroleum in Nigeria. So once you're going to be storing petroleum in large quantity, you'll be required to obtain a license from the minister. The license typically expire on December 31st of the year that it's issued. However, where you are really storing petroleum in significant bulk, there might be extensions. However, the renewal can only be valid for a period of 2 years. Where you're also transporting petroleum in bulk. So if you see the tankers, the virtual pipelines that we see all around when we're traveling on the express, you require certain licenses in order to transport petroleum in bulk because you know the hazards that go together with transporting petroleum products in Nigeria. And then we go to refining. There's also the petroleum refining regulations. Essentially, as I said in the beginning, the Petroleum Act says that you can't refine or construct a refinery or operate a refinery without obtaining a license from the minister. The refining regulations provides for the application process. It also states that once you've gotten a license to refine or to operate a refinery, then you can make certain changes to your refinery. So if the capacity of your refinery is going to be increased, then you still require the prior approval in writing of the minister. And also the petroleum refining regulations provides for the position of a manager of a refinery. And it says that the construction and operation of a refinery must be conducted under the direction of a manager appointed by the licensee. And I just thought to give you a picture of the refinery in case many of us may have heard of the refinery that is being built further down Lagos. And this just shows a picture of a typical refinery. The manager of the refinery must be in charge. He must take charge of all operations. And because the manager is so important to the operation of the refinery, the DPR must be notified where there's going to be a change in the manager. Also, in connection with refining, there's this provision that many people don't know about. It's that in order to refine in Nigeria, you require a license from the Nigerian Customs Service. This was premised on the provisions of a law called the Hydrocarbon Oil Refineries Act. It says that you must obtain a refiner's license prior to undertaking refining activities in Nigeria. So in order to refine, you must get one, the license from the minister, and then two, you must get this refiner's license from the Nigerian Customs Service. And you wonder, how does crude, how does it move? If you remember the first slide, I showed the different pipelines, essentially how crude moves from point A to point B. Either it's physical pipelines or you have virtual pipelines, which is popularly known as tankers. And the Oil Pipelines Act provides for the legal framework for the establishment, operation, maintenance of pipelines in Nigeria. The minister essentially is required to grant you a permit to survey. You determine the route where you want to lay your pipeline. You get the permit to survey covering that route. And then once the minister is satisfied, they issue an oil pipelines license. And that oil pipelines license enables you and grants you the full rights to run, operate, and maintain pipelines and to transport crude and other derivatives through the pipelines. The law is clear. Once you don't have that license, you are not permitted to construct, maintain, or operate a pipeline. And the license may be granted for such a period not exceeding 20 years. We tend to see that there's some thinking behind this tenure because it's usually tight. So you are drilling oil, you have an oil mining lease, which is for 20 years. If you're going to be investing in the supporting infrastructure that would take your oil from point A to point B, then you should be certain that for the same period of time that you will have the rights to drill and work and carry away crude or from the area covered by your license will tally and will be in tandem with the term of your oil pipeline license. Because essentially, there's no point in drilling the crude and not having the ability to transport it. So either you have the oil pipeline license, which enables you transport it, or you have to liaise with another entity or other entities that may have such pipelines. And similar to the oil pipeline, similar to the Petroleum Act, a holder of an oil pipeline license cannot assign its oil pipeline license or any right, power, or interest therein without the prior approval of the minister. We go over to the next law, which is a more recent law, even though it's 11 years ago. It was passed 11 years ago. It's the Nigerian Oil and Gas Industry Content Development Act, typically called Local Content Act. It was passed in 2010, and this was to encourage the utilization of more Nigerian impact in the sector because it was largely dominated by foreigners. However, the Local Content Act does not prohibit foreign-owned companies from operating in Nigeria. A foreign-owned company can set up its own Nigerian subsidiary and hold an oil and gas, oil mining lease wholly without having to have any Nigerian participation. However, there are certain benefits that accrue to Nigerian companies. And before I talk about the benefits, I'd like to define Nigerian company. So a Nigerian company is one that is formed and registered in Nigeria in accordance with the provisions of CAMA, with not less than 51% equity shares held by Nigerians. This provision as well has been tested by very ingenious lawyers, because the literal interpretation of this provision is that once a Nigerian holds 51% equity in the company, it will be deemed to be a Nigerian company. I know some of you are thinking, how can you structure away from this requirement? But all I can say is that you need to comply with the explicit provisions of this act, which says that 51% equity shares in the company that holds the OMO or the OPL. So what are the benefits? Why do I want Nigerians holding 51% equity in a company? The benefits are that Nigerian companies are the ones that have the first consideration for awards of all blocks. So in the marginal field bid rounds, they're going to be ensuring that it's indigenous companies, Nigerian companies, where they work in any land and swamp areas, operators are required to give exclusive considerations to Nigerians. And then in where there are contract bids, Nigerian content is actually a very important criteria in ensuring that you satisfactorily win the bid. And then there's the schedule in the Nigerian Content Act. This schedule essentially provides that certain services you must have every entity operating in the oil and gas sector. First, every entity operating in the oil and gas sector must comply with the terms of the Nigerian Local Content Act, right? Secondly, is that you must comply with the schedules, the threshold prescribed in the schedules, as it relates to man hours and spend for the different activities in the industry. So there are different activities in the oil and gas industry, which are listed in the schedule. Every operator must ensure that they are complying and they are meeting those minimum spend and minimum man hours requirements. For example, since most of us here will probably be lawyers, the schedule provides that 50% of legal work must be done by Nigerians. So we thank the National Assembly for passing this as they strive to make our profession a more financially rewarding one. We also look, just as lawyers have some benefits, Nigerian banks as well have some benefit because 10% of the revenues from the Nigerian operations are required to be retained in Nigerian banks. And then the very important and controversial provision. 1% of every contract awarded to any operator, contractor, subcontractor, alliance partner, or other entity in the upstream sector shall be deducted at source and contributed to the Nigerian Content Development Fund. So every contract relating to the upstream sector are required to deduct. Everyone making any payments relating to any contract in the upstream sector are required to deduct 1% of the contract sum. Just take it. Just imagine, you know how much those contracts are worth, and 1% of that sum is required to be contributed to the Nigerian Content Development Fund. That shows how liquid the fund should be, and that also the idea is to enable the fund develop programs that will continue to deepen the ability of Nigeria and Nigerians as players in the Nigerian oil and gas industry. But there are different controversies, right? So how do you define, how do you describe this? Are you taking the literal interpretation, which is that it, and you look at it very clearly, every contract awarded to any operator, contractor, subcontractor, alliance partner, or other entity in the upstream sector? There are two interpretations that I'm aware of. There is the wide interpretation, which I am sure the regulators prefer. Once the contract is in connection with the upstream sector, you pay the 1%. And I believe that's what the regulators will be deeming, will be seeking to obtain. But there's a restrictive definition because it can't be all the contracts, right? It has to be the contracts that are relating to the upstream activities. So it has to be contracts relating to winning and working and carrying away crude, because those are the upstream activities. You know, why? So for example, if I'm a caterer to an oil and gas company that is playing in the upstream sector, why is 1% of my money is being deducted? You know, I'm just a caterer, I'm just catering food. So so the restrictive definition or interpretation suggests that it should only relate to the activities that are directly linked to the upstream activity. You know, not generally all the contracts, but I mean, you'll find it a daunting task to convince the Nigerian Content Development Fund otherwise. The penalty, and these are the very interesting parts. The penalty for not making these payments is that you pay 5% of your project sum. So if your project was $1 billion and you failed to make 1%, just imagine how much you're paying as a penalty. Or the Nigerian Content Board can cancel the contract. So those are very, very stringent penalties, which essentially are trying to ensure that players in that sector do not risk taking the restrictive interpretation of that act and ensure that they continuously comply with the provisions of the Local Content Act. There are other laws that may not directly be oil and gas, such as the Environmental Impact Assessment. The Act, the AIA Act, essentially provides that where you are undertaking certain types of projects, you need to conduct an environmental impact assessment. I said, what does that mean? You need to know the impact of that project on the environment within which that project will be situated. And in that regard, you prepare an AIA report. Once the Ministry of Environment is fine and comfortable with that report, the ministry will issue you, or the minister will issue you an AIA certificate, which shows that your AIA report is satisfactory. So typically, for most projects in the oil and gas industry, because oil and gas falls under one of those projects that are deemed to significantly affect the environment, you will require the EIA certificate in order to progress your project. And in addition to this, I mean, depending on who you are, if you are a project sponsor, depending on who you are seeking your financing from, there are also other environmental impact assessment provisions, such as the World Bank Equator Principles, which may go a bit further than just an environmental impact assessment and start to look at an environmental and social impact. So not just the environment, right? How is it affecting people's lives? How is it affecting their livelihood? How is it affecting their ability to feed? So that's a deeper level, which is not necessarily under Nigerian law, but because many of our lenders in Nigeria and outside the shores are, are bound by the terms of the Equator Principles, it's something that project sponsors should consider complying with in order to ensure that their projects are bankable. And they will move to EGASPIN. It's essentially a guidelines issued by the DPR to control activities that have impacts on the environment, where you're exploring, producing, transporting, marketing gas. You need to ensure that you comply with the strict provisions of the guidelines. You need to also ensure that you get permits where you are seeking to discharge any gas, liquid, or solid into the environment. So those are essentially what the EGASPIN provides for. And then, as a commercial lawyer, I always follow the money. So you need to know what's the tax implication of the activity. PPTA, the Petroleum Profit Tax Act, that's the primary tax legislation dealing with entities engaged in upstream sector of the petroleum industry. And their tax is typically taxed at the rate of 85% of their profits or accessible profit. Where they are carrying operations within the first 5 years, then it's 65.75%. So there is a reduced tax in the first 5 years of the company's operations. And once those 5 years are expired, then they are hit with an 85% tax. And you're wondering, how is government making money if you're taxing 85%? I mean, how are all companies making money if government is taxing 85% of their revenues? That's one. Secondly, how is government saying it's broke if it's getting 85% of the petroleum profit tax? I mean, but I don't think I have the answer to that question. So maybe we'll leave that for another day. But for deep offshore, which has previously stated that government is encouraging people to undertake deep offshore activities because of the significant costs, you can see that their chargeable rate is at 50%, which essentially is just to give them an incentive because of the huge capital outlay that they will be undertaking. And it's very important to understand the definition of petroleum operations, because if you look at the last slide, you see I said it applies to PPTA, applies to taxation of petroleum activities in the upstream sector. And that's because of the unique definition of petroleum operations under the PPTA. So it restricts it to the winning, obtaining, transporting of petroleum, which includes drilling, mining, extracting, but does not include refining. So essentially, a refiner is not subject to petroleum profit tax. And in the course of a business carried on by the company engaged in such operation. So essentially, it's only for the entities that win and obtain and transport petroleum that are subject to this 85%. Once you are not, then you'll be subject to another tax regime, which will be discussed below. Many of us have heard of Finance Act. If you haven't, well, the Finance Act, as the government has been utilizing Finance Act to change certain provisions of laws, in essence, in order to ensure increased revenue generation. And the Finance Act also has an impact on the Petroleum Profit Tax Act. One of this was that previously, dividends from companies that have paid Petroleum Profit Tax Act, that have paid Petroleum Profit Tax, were not required to withhold any payments. So where a company that has paid PPT makes any dividend payments to its shareholders, they were not required to withhold any tax from such dividend payments. However, the Finance Act repealed that provision. Consequently, petroleum companies who have paid PPT and are paying dividends are required to withhold a 10% withholding tax from the payment of such dividends. Another significant impact of the Finance Act on the on the tax implications as it relates to oil and gas companies. Previously, there had been arguments as to whether um, oil and gas oil wells were subject of value-added tax. Different cases had been in court on this matter, but the position is now settled. The Finance Act, together with the FIR circular, which was issued to provide some form of clarification on the provisions of the Finance Act, have essentially included as vatable goods under the Act to include tangible or intangible property, such as rights in goods or property, oil wells, and rigs. So, premised on this provision of the Finance Act and the interpretation handed over by the FRS through its circular, under Nigerian law as of today, VAT is charged on the on oil wells. So where an entity is transferring an oil well, they will be required to pay VAT. Such transactions will be subject to VAT. And I said that petroleum operations, if you are not undertaking petroleum operations, you are not covered under PPT. So once you are not covered under PPT, you fall under the company's income tax. And the regular company's income tax that applies to every other company applies to you. So essentially, you are getting a reduced tax rate from 85% to about 30%, depending on the type of company that you are. This is a very beneficial provision for refiners, as I previously mentioned, also for entities involved in gas, because they are not deemed to be undertaking petroleum operations. They will fall under entities subject of CETA. I just also thought, whilst I just also thought to mention that there's a Nigerian National Petroleum Corporation Act, which essentially establishes the NNPC, which is the federal government's oil company. The NNPC is the one that participates in petroleum operations on behalf of the federal government. People tend to say the NNPC is actually the biggest oil company in Nigeria because it typically holds 55% of majority of the oil fields, either directly through the NNPC or through its wholly owned subsidiary NPDC. How does NNPC participate with foreign oil companies or Nigerian oil companies? So it enters into arrangements called joint operating agreements or a production sharing contract. I know that further down the line, subsequent days in this training, there are classes that are tailored specifically to deal with this. So we'll not dive deep into what joint operating agreements or production sharing contracts are. Also through the NNPC, there's a body called National Petroleum Investment Management Services, which is NAPIMS. NAPIMS essentially tries to supervise and manage federal government's investments in the Nigerian oil and gas industry by ensuring that the costs that are incurred are controlled and ensuring that the practices on those fields are in line with best practices. And yes, in the process of oil and gas exploitation, there can be spills. We typically hear of different spills happening in the Niger Delta. We see some very gruesome images of the impact that oil has had on some of some of these Nigerians and their environments. And the Office of the National Oil Spill Detection and Response Agency was established by the Act, which essentially gives that agency the ability to coordinate and the powers to implement a national oil spill contingency plan. Also helps in ensuring that wherever spills are done, they're properly cleaned up and adequate compensation is paid to whoever may have suffered or incurred certain losses as a result of the spills. There's also an Education Tax Act, which, as with other companies, imposes a 2% tax on accessible profits on oil and gas companies for development of Nigerian educational sector. I mean, this applies to all companies doing business in Nigeria, so we won't go any detail. And then there's the NDDC Commission Act. The NDDC Commission Act establishes the NDDC and mandates that oil and gas companies pay 3% of their annual budgets for the development of Niger Delta areas where oil and gas is exploited. So essentially, oil and gas companies are required to pay 3% of their budgets to the NDDC, who then is supposed to use those funds in developing those areas, building roads, building bridges, building schools and hospitals, essentially just trying to compensate the Niger Delta, people living in the Niger Delta, for the impact that they may face as a result of the exploitation of crude oil in the Niger Delta. Please don't ask me if this is being adhered to in line with the provisions of the Act, because I'm sure we are all privy to the drama that we witnessed at the National Assembly last year. And there's the agency that we should all be frowning at the moment, depending on which side of the divide you belong. The PPPRA Act establishes the Petroleum Products Pricing Regulatory Agency. This is the agency that has the powers to establish the benchmark for the pricing of petroleum products in Nigeria. And today, we've got an announcement that the benchmark had moved and that the subsidies had been removed, and the cost of premium motor spirit, which is typically called petrol, had gone up to over 200 naira a liter. And just before I got on this, I saw a conflicting report saying that the government had backtracked. I mean, but who knows what we're going to see? But the queues appear to be back just because of the announcement. So this entity and this law establishes that entity which should provide a benchmark. Many of us have argued why we require a benchmark. Many of us believe that it's time for Nigeria to do away with subsidies and providing benchmark, because the government should always enable the market thrive and let the market indices drive the pricing of products. So, for example, why should petroleum products be the same price all around Nigeria? I mean, whoever is closest to the refinery or closest to where the crude is and it's being treated and utilized and changed or refined into petrol should not incur additional transportation costs that someone that is far away from where that refining is happening. So the price in the petroleum product should not necessarily be the same. I think a lot of politics has gone into the pricing of petroleum products, but we should be devoid of politics and focus on what's best on the economy. And the only way the economy will thrive and the only way you will drive investment is the less government has an impact, or less government has control, or less government directs things like price, the better for the economy. And then we move to Associated Gas Reinjection Act. And as I said in the slide where I was showing the value chain, gas is typically found either associated or non-associated. So non-associated gas means that you have gone out of your way to look for gas, and you are developing gas fields, and you are seeking gas, producing and utilizing. However, associated gas is you've gone to look for oil, but then you see gas. What do you do with it? And this law essentially provides that you can't flare gas. You know, we see those pictures when you just Google gas flaring. The first thing you see is Nigeria. You know, we see different images of how horrendous these activities are. But you can't, I mean, the oil companies go there to seek the oil, right? And they get a byproduct called gas. If the infrastructure or if the economics do not support them investing in infrastructure to utilize this gas, they will choose the cheaper option of just flaring it. And it's a funny scenario because whilst the act prohibits flaring, it also says that the minister can permit you to flare. And the minister permits you to flare because the minister and such permits will be subject to receiving certain payments for flaring of gas. So in essence, once you pay, you can flare. So you're wondering, is the act focused on prohibiting gas flaring or on revenue generation as compensation for flaring? And I don't think I can answer that at this point. But just a brief summary, you're not required to, you're not permitted to flare gas unless you have the approvals of the minister. And those approvals are typically called gas flaring certificates. And just to add that one of the penalties for flaring gas without approval is that it may result in the forfeiture of your concession. So your oil mining lease may be forfeited. And I believe we can move, I think we're done with oil and we can move to gas, yes. Yes, gas. Some of us are advocates of gas. Gas is the future. Nigeria is a drop of oil surrounded with gas. We hear all this very, very flowery language, right? But is there any legal framework for gas? The Petroleum Act was largely oil-centric. You know, gas was a byproduct. So over the years, government has tried different methods and thinking and seeing how they can improve the utilization of gas in Nigeria, knowing that, as we talked about in the last slide, there's a lot of gas flaring. So rather than people pay to flare, let's try and develop policies that will enable people to utilize that gas. So what did the government do? In 2008, there was a national domestic gas supply and pricing policy, which essentially provided a framework for increase in domestic supply of gas in Nigeria. That policy divided the market and tried to provide some form of incentives for specific players. So, for example, um, there's a strategic domestic sector, which are largely power plants, power off takers. So you and I in our homes, certain amounts of gas must be allocated to the power sector to enable you and I have electricity in our home. That feedstock. Government as well was trying to drive and increase supply to those sectors just because of the impact you have on the economy. I mean, methanol and fertilizers. Imagine more fertilizer companies. That will lead to increased agriculture. That will lead to increased food supply and hopefully benefits the populace. Government also looked at certain commercial sectors that required gas for their operations. big sectors like the cement companies, the steel companies, they need gas to fuel their plants. So government are trying to focus on supply to them because, hey, these sectors as well have huge employment, uh, help fix huge unemployment in Nigeria because they engage many workers. So a lot of people have jobs and a lot of people to meet their daily needs. So government was trying to ensure that gas is supplied to those three, at least to prioritize to those three sectors at a price that was that was beneficial to the sectors. So, in furtherance of the policy, the minister issued the National Domestic Gas Supply and Pricing Regulation. Um, this essentially introduced a concept called domestic gas supply obligations. And what is domestic gas supply obligations? What it means is that a portion, every oil and gas producer in Nigeria, a portion of the gas that they produce must be utilized in Nigeria. So the government looks at the gas reserves, looks at their gas capacity, and says, look, a portion of this must be sold to these three sectors. And and in that regard, government also set up an entity called Domestic Gas Aggregator, which later became the Gas Aggregating Company of Nigeria. The domestic gas aggregator was to essentially utilize this domestic gas, try to be a middleman between the buyers and the sellers, and to ensure that the gas is adequately allocated amongst the three sectors that government had identified, and to ensure that the sellers be able to meet the gas supply to the buyers, and the buyers be able to meet their payment obligations to the sellers. So the domestic gas aggregator was essentially just like a middleman who was aggregating all the gas and just taking the gas from where it is to where it is needed. And there was, I mean, so the price of domestic gas was typically regulated, and I think current price is $2.50 for the power sector. So essentially, government was trying to get the power sector cheap gas so that will help drive and increase electricity supply in Nigeria. And I mean, without penalty, there is no law, right? So government provided that where you don't meet your domestic gas supply obligations, there were two significant penalties. One was that you pay a penalty of $3.50 for each quantity of gas that you did not supply uh, in line with your domestic gas supply obligations. And then two, you are restricted from exporting any of your gas. And if you know, most of the players in the market, at the time they invested in the gas projects, what they were seeking to do was to export to LNG, to liquefied natural gas projects, and to export to neighboring countries. So the big incentive was that they wanted to export. Also because the price at which at that time that they were exporting was much higher than the regulated price of $2.50. So there was always an incentive to export. So the penalty of stating that they will be restricted from exporting was a significant deterrence to enable them meet their relevant domestic gas supply obligations. And then there's a gas infrastructure blueprint. The blueprint essentially covers all the network and the gas processing facilities that will be required to enable gas flow smoothly all around the country. And those were the three documents that, as at that time, formed the Nigerian Gas Master Plan. And this was in about 2008. And this is 2021. And where are we? What has moved? The Nigerian Gas Master Plan was aimed at stimulating multiplier effect of gas in the domestic economy, positioning Nigeria competitively in high-valued export markets, and guaranteeing long-term energy security of Nigeria. Did the Gas Master Plan attain this objective? I'll let you be the jury. But I mean, in 2017, the federal government as well issued a new policy, a national gas policy, which essentially just articulated the vision of the federal government and set out the different strategies and the implementation plan um, to prepare and provide an a legal, regulatory, and commercial framework for the gas sector. What the real crux was that the government was seeking to remove any barriers that will affect investment and development in the gas sector. Flowing from there, in about a year ago, just as we understood that the transportation mechanism for gas is typically through pipelines. Majority of the pipelines are owned by a federal government entity called Nigerian Gas Company, and in the Nigerian Gas Company issued a network code on February 10, 2020, which was to regulate the use of gas of the gas transportation system owned by the NGC. What this did was that anyone that was seeking to utilize NGC's gas transportation system will be required to comply with the network code. Prior to this, different entities entered into gas transportation agreements with NGC to take their gas from point A to point B. What NGC is trying to do is to have one grid where there's open access and enable people utilize standardized quality and enable people utilize an open access transportation system. Then the network code provided for a 6-month window for legacy agreements to migrate into the network code. Yes, it was launched February 10, but then I believe it became effective 6 months after. And the migration actually should have happened by February 10, but 2021. But I understand that that hasn't been done, and the NGC is still in the process of finalizing that migration process. Once that is done, everybody will be enabled to utilize the network code once you have your license, because you're typically expected to obtain a shipper's license, whether you're a gas supplier or a gas off-taker. And the key objective of this code is to ensure fair and non-discriminatory access to gas network. So what it is try and make it as open as possible so that all the gas players can utilize this network easily, and that will help drive increased utilization of gas in the Nigerian domestic sector. And we moved to the DPR guidelines. And I remember saying that that I was going to provide how the regulator reacted to ingenious means of structuring transactions. Um, the DPR in 2014 passed a guideline. And just to give some backstory for the case, in the event that certain people were not here when I stated that, paragraph 14 of the Petroleum Act, of the first schedule to the Petroleum Act, requires you to obtain a minister's consent where you are assigning your interest in your OML, oil mining lease, or you're assigning your oil mining lease, or you're assigning any rights or obligations under your oil mining lease. The literal interpretation means once you're not doing that, then you don't require the minister's consent. So in essence, if you are transferring shares in an entity that holds an oil mining lease, then you are not required to obtain minister's consent. Flowing from that, certain people undertook transactions, which were share deals, which sold majority interest in the entities that held OMLs. And then a court case, the Monipolo case, held that where you transfer majority shares in an entity that holds an OML, then you'll be deemed to have transferred the OML, and therefore you'll be required to obtain the consent of the minister. This guideline was introduced to show more, to provide more, to provide more information or more clarity as to what it means to sold a majority interest. Here, the government went to town, and the provision of the guidelines were so widely drafted that if you transfer one share in an entity that holds an OML, you are required to obtain minister's consent. That for me is a bit absurd because we have, public companies who are listed on Nigerian Stock Exchange, on the London Stock Exchange. Are you saying every day that a transaction happens that they're required to obtain a minister's consent? It makes no sense. Also, when you look at the requirements for obtaining minister's consent, the things that the minister has to tick off, which is that you have the technical ability, you have the financial capacity. Is the minister going to check that for someone buying one share? It makes no sense. So I still believe that the rationale for these guidelines was still to catch a majority sale transaction. But in order to restrict parties from being ingenious, the guidelines were drafted so widely. And this applies to transfers in all prospecting licenses, all mining leases, marginal fields, and oil and gas pipeline licenses. So once you are transferring any interest in any of those, you require the minister's consent, and then you need to comply with the procedures provided in these 2014 guidelines. Luckily for the down sector, in 2020, DPR issued a subsequent guideline, which essentially tries to cure the absurdity of the previous guideline. For the down sector, it only restricts the transfers to transfers that relate to takeover or a merger and acquisition. That appears to be more in line with the ratio decidendi in the Monipolo case, because that's the only, if you are transferring minority interest, then really you're not really acquiring any indirect interest in the mining lease. So I am more amenable to this revised guideline, but this applies only to the down sector. It may be useful for the DPR to consider updating the 2014 guidelines in line with this 2020 guideline. And the DPR is the most active in the sector. So the DPR has all other guidelines. And I'm sure if I start talking about all the guidelines that DPR has issued, we won't leave here today. But a couple of key ones, guidelines and requirements for application for oil and gas and industry service permits. So if you're an oil and gas service provider, you need certain permits from the DPR. These guidelines provide the requirements and provide the steps you need to take in order to obtain those permits. If you are trying to set up a refinery, there's the hydrocarbon process plants guidelines as well, which will detail that procedure. If you are trying to open a petrol products filling station, you have a guideline that details the approval process. If you are trying to establish a natural gas facility in Nigeria, you have the guideline as well that details that process. And for marginal fields as well, for every bid round, the DPR tends to issue marginal field guidelines, which essentially provides the requirements that will govern that marginal field bid round, i.e., what's the indigenous participation, what's the arrangement with your farmers, what's the procedure for renewal of your lease. So for each marginal field, what's the procedure for paying your signature bonus, the procedure for the bid round itself. Those guidelines are typically issued from time to time once there's a bid round. And there is a very interesting guideline that applies to oil and gas workers, you require the approval of the DPR on behalf of the minister. if an oil and gas company is seeking to terminate the employment contract of one of its employees. This is a very interesting one as well, because I mean, is it every employee that's what makes an oil and gas employee different? Why should an employer require the minister's consent in order to terminate the employment contracts of an oil and gas employee? So, as I said, there are numerous guidelines, and the DPR's website is actually a very, very useful tool. Many of these guidelines are provided there. So, if anyone needs to get any copy of any guidelines, you can just log on to the DPR's website and you can download any of the guidelines. And I just thought, I mean, most of this, just thought to highlight the regulators. We'll breeze through this because most of the regulators we've talked about during the course of the presentation. And talked about the minister and the powers to grant licenses and leases. Talked about DPR being the operational arm of the ministry, supervises and ensures that there's compliance with environmental issues, administers gas flaring penalties. We've talked about the NCDMB, which essentially regulates the compliance with Nigerian content requirements. We've talked about the Nostra, which detects and administers cleanup of oil spills in Nigeria. We've also talked about NNPC/NPDC, not necessarily a regulator, but a major participant in the oil and gas sector, as they hold interest on behalf of the federal government of Nigeria. We've talked about the Petroleum Products Pricing Regulatory Agency, which regulates the price and creates the benchmark for petroleum prices of petroleum products in Nigeria. We haven't talked about the Petroleum Trust Fund Management Board. So this is typically responsible for managing the Petroleum Special Trust Fund into which monies are paid. Monies received for petroleum products are paid into in order to. So what this Petroleum Trust Fund does is that it takes these monies and just utilizes the monies in developing certain aspects of the country. Where you are seeking to undertake an oil and gas activity within a free zone, you have the Oil and Gas Export Free Zone Authority, which manages and administers the oil and gas free zone. It grants all the approvals, permits, and licenses required in order for you to be an approved enterprise within the zone. We've talked about the NDDC. And I think lastly, we'll talk about the Petroleum Equalization Fund. The PEF is a very interesting one. Essentially, what the PEF is set up is to compensate all marketers for losses that they may incur as a result of a uniform product price in Nigeria. So, as I previously had talked about when we talked about the subsidies and whether they should be removed or not, if you are a producer in Lagos, if you import, you import petrol in Lagos, petrol being premium motor spirits, you have to incur costs via a tanker, a virtual pipeline, to take it from Lagos to my home state, Ekiti. Let's say that cost is 10,000 naira, right? The man that is in Lagos will probably just need 1,000 naira to transport it from Apapa Port to Ikoyi. In essence, the difference in transportation costs between the man in Lagos and that is transporting to Ikoyi and the man that is transporting from Apapa to Ekiti is about 9,000 naira. But the marketer cannot put this increase. It can't price this into the cost that the purchaser will be paying, because the cost of premium motor spirits across Nigeria is deemed to be uniform or in the same region. So those marketers that those marketers would not be encouraged or incentivized to go all the way to Ekiti to deliver premium motor spirits there unless they are compensated. So the Petroleum Equalization Fund is that fund that essentially gets any net surplus revenues in order to compensate those marketers who are incurring additional losses as a result of the uniform product price in the country. And then we move to industry reform. I know that there's a detailed presentation on this industry reform, so I'm not attempting to go into it in detail. This is just a cursory overview of the industry reform, and that's the Petroleum Industry Bill. I remember many years ago when the National Assembly first, when the executive first submitted the first bill to the National Assembly. That was in 2008. I remember well because that Christmas was not a very interesting Christmas because we had a client that we had to review that bill on their behalf, and it was a very challenging period. It's sad that 12, 13 years down the line, we're still here talking about a PIB. However, why the PIB? The Petroleum Act passed in 1969. I mean, the law is over 50 years. We can't expect that the laws that were made then will still be applicable now. We can't expect that the incentives that were granted then are still useful now. We can't expect that the law that was premised or that was targeted at crude oil production will still be in the same manner without essentially providing for any specific provisions relating to gas. And there were different other lacuna in the law. So yes, we needed an improvement. But what an improvement. 13 years down the line, we've seen different structures. First, it was one bill, then it was bifurcated, then to 4 bills, now back to 1 bill. So we've just seen different petroleum industry bills, and it's getting some of us a bit jaded. And we're just hopeful that there will be progress on this bill. Essentially, the PIB is to have a wide-ranging modification of the existing governance framework for the industry. The main objectives: to create an efficient and effective governing institution, to create efficient and effective governing institutions with clear rules for the industry, establish a framework for creation of a commercially oriented national petroleum company, promoting safe and efficient operation of the transportation infrastructure for the petroleum industry, enhancing peaceful and harmonious coexistence between licensees and host communities, and establishing a progressing fiscal framework. The reforms in the PIB. The PIB establishes a Nigerian Upstream Regulatory Commission. That's the entity that's going to essentially govern the upstream sector of the oil and gas industry in Nigeria, taking over many of the powers of the DPR. And the PIB also establishes a midstream and downstream regulatory authority, which will also take over most of the downstream activities of the DPR. The PIB also proposes the incorporation of a Nigerian National Petroleum Company Limited, which would be a company typically meant to be a company incorporated under CAMA, but still has some form of government interference. Then the intention is to ensure that the NNPC, as it is now, is transformed into a corporate and profit and commercially driven national oil company with a possibility that it will be able to obtain its own financing, do some listing on the capital markets in future, have a very qualitative board, and essentially just try to play as a commercial entity in the sector. The PIB proposes a national grid system for accurate management, So what it does is it divides the entire country or the entire areas where crude can be found into a grid where they're in equal portions, and any subdivisions are also in equal portions. They're clearly in parcels of 1 square kilometer, which will enable easier management so that it's easy to determine what portion of area has been allocated to one entity, and enables different people have different parcels within what was previously known as the lease areas. It provides a new licensing regime rather than the OEL, OPL, and OMLs. It's not just a name change. It's a petroleum exploration license, petroleum prospecting license, and petroleum mining lease. Not just name change, as I said. The term of each of these license and leases have changed. The format in which they were granted have a bit changed. If you also look at the next provision, which deals with the ability to assign your rights in your mining lease or your prospecting license, we'll see that there's also been a change in the provision, and this is a forward-thinking change because we've seen on previous occasions where the grant of consent has become political, where uh, certain oil and gas players don't get consent for a long time, which is not necessarily good for the market. So here, the minister is still required to grant the prior consent, but it only does so on the recommendation of the Upstream Regulatory Commission. And one other key thing as well is that the minister's powers generally have been a bit whittled down. What the minister is now required more to act from a policy perspective, and most of the decisions that were taken by the minister are upon the recommendation of the Regulatory Commission. And the PIB also anticipates a new tax and fiscal framework. It splits the current PPTA into an hydrocarbon tax and companies income tax. So previously, companies in the petroleum, companies undertaking petroleum operations were required to pay 85% tax or 67.25% tax in the first 5 years of their operations. Now it has been changed. They are now required to pay between 42.5% to 5%, depending on where they are operating, if it's onshore or deep offshore, and then required to now pay the additional company income tax like every other entity. So if you look at it, a 30% plus a 42.5%, I mean, you can't use those numbers literally, but it looks like this seems to suggest a better fiscal and regulatory framework for the oil and gas operators. And I think I want to end on this point, the point relating to the host communities. Every holder of a PPL, PML, or any license for midstream operations in any area within a community is mandated to incorporate a trust for the benefit of the host communities and to contribute 2.5% of its operating expenses to the trust. So in essence, any company doing business in the Niger Delta area amongst any particular community will be required to set up trusts, and 2.5% of their OPEX in the previous year will be contributed to the host communities. This provision has been very controversial, and this has been one of the things that I believe may have slowed the progress in the petroleum industry bill. One is the significant amount of revenue that's going to be generated by these communities. Secondly, is that I've seen newspaper reports where certain governors have said, no, 2.5% is too small, it should be 10%. So, I mean, the discussions on this will be very interesting to watch as the days go by, as we understand that the National Assembly is seeking and is desirous of passing the new version of the Petroleum Industry Bill this year. My view is that no law is bad law. And many businessmen will tell you that they'll rather have bad law than have no law. No law being uncertainty. Uncertainty is bad for business, even though Jeremy Bentham believes that the lawyer benefits, the lawyer shows the skill when the law is uncertain. I believe that the economy does not react well to uncertainty. I believe that the petroleum industry bill has stayed too long. Back and forth have been unnecessary, and it's time for Nigeria to get its act together and either pass this petroleum industry bill, because there will never be a perfect law, or immediately jettison passing any petroleum industry bill, so that at least investors and participants in the oil and gas industry would know the laws and the regulatory framework that will govern their doing business as they progress. I hope that I haven't bored you too much, and I would like to end on this note, and I'm available to take any questions, any feedback, as the panelists or the organizers may deem fit. Thank you very much, everyone.
All right, thank you very much, Deji. It was indeed a great session. I actually listened throughout. I'm not an energy or oil and gas lawyer, as you know, but it was very interesting, very informative. Coming from, very specialized law firms like we all, people come from, we know that, everyone is allowed to develop in their own area so that you become an expert in that area. So thank you very much. Well done. So I'm just going to go through to the questions. Thankfully, two of our panelists have, been answering the questions for us. So I'm just going to quickly go through them. And if there's any of the panelists here that you would prefer to take those questions, if it's going to come in their own during their own segments, please just inform the people who ask the questions so that they can wait for that session. Okay, so we'll just go straight into it. So the first question is, the OML shall be renewed for how many years? I think that's very straightforward.
That's straightforward, 20 years.
Okay.
And indeed, I think last year, 2019, a couple of OMLs were renewed for 20 years.
Okay, so I can see that Ayodele is answering the very long question on the oil field. Okay, so most of the questions are as to if the presentation is going to be made available. Yes, the Institute, the ICL is going to put together all of the sessions that we have had since the IP, tech media, and then this one. Then we're going to put it all together and let all the participants, delegates have it in a very organized manner. Okay, so this is by virtue of the registration with the Lands Registry or by virtue of nature, do you then consider an OML as an interest in land, running with the land, for instance? Sorry.
That's an interesting question. So we consider an OML as a right? You have the right to walk, to win, to carry over. So it's a chosen action rather than an interest in the land. Because if it's an interest in land, then you now have to comply with certain requirements under the Land Use Act, such as obtaining consent of the governor, stamping, registration. No, it's not an interest in the land. You don't have an interest in the land. You just have the right to go in there, utilize the property, take whatever you see and go, not having an interest in the land. So I hope I answered the question.
I know where that's coming from. The land law in university just comes back to mind. Okay, so what is the difference between royalties, rent, tax, since it seems companies need to pay them all? For instance, if PPT is 85%, where will rent and royalties be deducted from?
Okay, I mean, so the idea, there's a difference between rent, royalties, and tax. We need to understand there's always a clash between the host nation and the oil and gas company, right? So the host nation wants to get as much money as early as possible, while the oil and gas company wants to delay making payments till as late as possible. So the distinction between the rent, royalty, and tax is at the time when the money is being paid. So the rent, once you have the OML, you pay the rent every year, right? Whether you produce, whether you don't produce, you pay the rent. The royalty, once you are producing and you are getting sums, you take it's a first line charge. So you pay the royalties first before you now start working your field, spending money, incurring costs on different activities, which will now go into the computation of your tax. Then you make a payment on tax. So the tax is a form of deferred compensation to the government, which enables the oil and gas company do business, take away the cost they've incurred in doing business before they are taxed. But the royalty is, look, it's my land. I must get some benefit upfront because I need to run my budget. I can't wait for you to make profit before I start running my budget and paying salaries to my employees. So government needs a part of the money ahead of time prior to you doing your business, making your profits or incurring costs and then deducting your taxes.
Okay, so I think this is going to be a follow-up question to that. Having seen the new Finance Act and its impact on the tax obligation of the upstream oil and gas companies, can the stabilization clauses in these oil and gas contracts be invoked by the concerned companies?
I mean, that's also a very interesting question, and that's definitely not from uh, an elementary participant. Yes, I mean, stabilization clauses generally, right? They are to put you in the position that you were prior to the enactment of the law. So once you have that stabilization clause and it's written in your contract, in your PSC mostly, and it's in your contract, then you should be able to enforce that stabilization provisions of your contract. Sometimes I mean, and you know that we know the entities that have stabilization clauses in their contracts, they as well may not be willing to enter or enforce those provisions because it's usually a negotiation, it's a give and take. There are certain benefits that they might not be meeting or certain requirements that they have not met. So you don't want to go to a government enforcing something if you as well you haven't done certain parts that you should have done. So it's a negotiation. Yes, if you have those provisions in your contract, you should be able to enforce the terms of your contract to put you in a position that you will have been prior to the enactment of the law.
Okay, so there are lots of questions about the news that we woke up to 212, and Nigerians and the memes that have gone out today. So what I'll do is most of those questions we're going to, if you can post your so I'm actually referring to the panel, sorry, to the delegates now. If you can post your email addresses. Oh yeah, we do have them. We will send you the answers because we just have 15 minutes. We have to round up in the next 11 minutes. So the next one is, what is the position of the Energy Commission of Nigeria Act that establishes an agency charged with the responsibility for the strategic planning and coordination of national policies in the field of energy and ramifications?
I mean, just as you said, it's largely a policy establishment, which essentially is just to try to get a right mix of energy in the sector, renewables, gas, just to ensure that it's a right mix and a right blend. So it's largely a policy institution, not necessarily an effective one.
Okay, so does the Oil Pipelines Act also apply to gas transportation through pipelines?
Yes, the Oil Pipelines Act essentially, if you're transporting anything through your pipelines, either crude or gas, then you require to obtain an oil pipeline license in accordance with the provisions of the Oil Pipelines Act.
Okay, this is a very interesting question. In fact, I'm actually really interested in this question on the point whether a foreign company can own an OML or OPL. Is it possible for a locally incorporated company to hold an OML OPL license and then license same to a foreign company?
When you mean licensing, what does that mean? Because there are restrictions that I have highlighted in paragraph 14 of the first schedule. So you can't assign your interests or rights without the consent of the minister. So that's what I'm trying to understand what you mean by licensing it, because in essence, you can't give out what has been given to you without the minister consenting. If the minister is fine with it, then that's all well and good. There are other creative structures that you can utilize, and I can discuss those offline, where for a foreign company is seeking to do business in Nigeria. And I mean, as I said, we can take that structure offline.
Thankfully, this session is going to go on for 16 weeks. So there'll be opportunity for all of these questions to be answered. Please, we're going to continue to send out information on we sent out information on the different times that these sessions are going to go on for. So we encourage everyone to actually take part, because there's no how throughout the 16 weeks, most of these questions will be answered. So with regards to PEF, what is the relevance in view of the purported full deregulation of the downstream sector?
I mean, so if there's actually a full deregulation, then we don't need any PEF, because no compensation. People will be able to price the PMS, premium motor spirits, to cover whatever cost they incur in transporting it in any part of the country. So ordinarily, where there's no subsidy, there's no price gauging, and it's all determined by market, then we typically will not require a petroleum equalization fund. The only challenge, and you and I would know, is that it means that certain people will lose their jobs. So government doesn't like to sack people. So there might just be an institution that still remains and maybe just overlooks overlooks the pricing, even though the pricing is largely regulated by market.
Okay, so I think this is an interesting question too. If the OML is to be registered to the land registry in the operation states, are they also to pay rent to the state government? Bear in mind that you said it's a federal, together with the federal government, won't it be double tax and double payment for rent?
Yes. So there's a part of the slides where I highlighted the fact that the Petroleum Drilling and Production Regulation says that you are required to comply with all town planning laws, and that secondly, where the state law permits the governor to have certain rights, then the governor has those rights. Thirdly, where the state law requires that you make certain registrations within the land registry, you are required. So where the federal law has given the state certain places where they can pass laws that will be validly and in effect and apply to oil and gas companies. So yes, so long as it's validly done and it doesn't affect the oil and gas operations itself. And indeed, we've seen some of those being done in certain parts of the country.
Okay, so just before I hand over to the lead of this faculty, I'm just going to ask you, did you remember you said that no law is bad law? It is actually, we don't want uncertainty. And we all know that the PIB has been, in fact, since I started practicing law, I've been hearing of the PIB. Don't worry, in my sector, we have laws that, have been going on and on for so long that are bills, So this question says, will the passing of the PIB mean a proscription of DPR and PPRA considering the powers of the Regulatory Commission under the PIB?
Yes. So I said the commission and the authority will essentially take over most of the power or all the powers of DPR and PPRA. So yes, once the PIB is passed, we will no longer have a DPR. We will now have a commission.
We're waiting for the day when our laws will really be set in DG. All right, just before I hand over to Dr. Oni, this is the last question. So it says, if I got you correctly, you said during the presentation that the holder of the OML has the right to deal with the oil found in any manner he wants, provided he complies with Nigerian law. Please, I want to know if the laws you are referring to here include the oil contracting agreement signed by that oil company or just limited to legislation.
I mean, so it's you have to comply. I mean, pacta sunt servanda. We are bound by whatever you sign, right? So if you have a contract, you typically should adhere to the contract. But if you don't, what damages? And if the court thinks that damages do not suffice, then they will mandate specific performance. So for a contractor perspective, there's the avenue to resolve that. But from a legal perspective, yes, you have the rights to the crude, and you can deal with it in any way, but there are certain requirements, right? So you need to transport the crude. You need to ensure that, I mean, you're transporting through valid pipelines. You need to export the crude. There are crude export terminals requirements where you need to ensure that there's certain meters that you can measure. So there are other legal requirements that you need to comply with. Even when you export, there's the export repatriation of proceeds, crude proceeds. Within 90 days, some of the monies have to come back into the country. So there are other legal requirements that you will comply with as an oil and gas player in the market. But what I generally said is, once you have an oil mill, you have the right to utilize, because the law grants you the right to win, to carry, to dispose. So, I mean, you have entirely the rights to do with the crude in whatever manner that you deem to deal with it, subject to complying with all existing laws that may be applicable.
All right, thank you, Deji. And I want to thank thank you for all our panelists that are still on. Dr. Oni, I'm going to hand over to you right now, but I just wanted to inform everyone that the next session is on Tuesday and Wednesday. So next week, we're going to have 3 sessions, which is the 16th, the 17th, and the 19th. Please log in and let's continue this very interesting session. Dr. Oni, over to you, please.
Thank you very much, Inter. I mean, we also refer to you as NTA. Thank you very much. Deji, thank you very much, my brother. It was such an interesting session. A lot of lessons. I mean, there are several pieces of legislation in the oil and gas industry. First rule of thumb is, if you are going to do any transaction in that space, you must first assume that there's a law regulating that activity. So you start from that assumption and then maybe eliminate the laws. A number of questions around number of pieces of legislation and all of that. And I was responding to some of those questions. We probably have up to 100 pieces of legislation. From backing rights, I mean, people may not be aware that even when you have an oil block, particularly where it's indigenously held and it's a deep block, government can back in some cases take up to 5/6 of that block. So there are several things. Even when you do your transactions, you need to be aware of the law so that you know what reps, what warranties you should be asking for. And they've done an excellent job giving us an outlay of what the rules, what the regulations generally are. And this is just the beginning. And there's more to come. If you hold on and are patient, you would enjoy the entire program. It's 16 days. I think we've got 15 days to go. Next week, like Inter had mentioned, there'll be a number of other sessions, very interesting sessions, as interesting as Deji's session was. So we thank you very much. We are grateful and we appreciate your time. I would let Tobena round up now. Thank you very much, everyone.
Yeah, Ayodele, thank you very much. Very special thank you to Deji for a brilliant presentation. I mean, taking us all the way from Olubiri in the 1950s to a time unknown in the future with the PIB and going through a raft of regulatory, instruments that, define the oil and gas space is actually amazing. Thank you for a brilliant job. And I found it quite illuminating and very simple to follow. I don't know that many could have delivered it so brilliantly. So thank you very much. I just want to say a special thank you to everyone who's logged on. I think we had altogether about 1,000 people logged on today. I encourage you to take these things very seriously. I thank uh, Akin Deji, Oyebode, Ayodeloni. I also thank Shola Arifi, Stella Duru, Dioya Defulu, Dolabo Kukuyi, Desmond Oba, Yemi C. Awonuga, Olajumoke, Fajemiroku, Yemi Oke, Aderemi Ogumbanjo, for the time they've spent working on all of this. It is not easy, seeing how busy everybody is. So thank you very much, and I hope that people take this seriously and participate in all the sessions. So see you on Tuesday the 16th, and God bless you all. Thank you. Bye-bye.